Most people think moving to the UK legally is impossible, but this is because they do not know. Today, you are going to get first-hand information that could change someone's life. Without wasting your time, can you please introduce yourself to the audience?
Hi, everyone. Once again, thank you very much for having me on this program. I'm Lawrencia, and I specialize in immigration law in the United Kingdom. I'm a qualified solicitor. So I hope what I'm going to do today is going to benefit a few people. Thank you very much for having me again.
Thank you, Lawrencia, for joining us today. So we've got a list of questions from our audience. The first question that we have is that if someone who moved to the UK on a carer's visa and had children who were under 18 when they came to the UK, and their children haven't lived in the UK for 2.5 years, their children have now turned 18. They are now over 18. What are the chances of those children and how do they apply?
Now, the Home Office have taken into consideration this group of people, and the immigration rules actually provide for them. So they can still make applications for those children, even though they are now 18 years old, provided the children came into the country as their dependent and they are not leading an independent life. So for instance, the child entered the country with the main applicant or the sponsor of the application, maybe when they were 16 years old. Now they are 19 years old. Now, the fact that they are 19 years old does not preclude them, from remaining as dependents on the main person's application. What they have to prove is that the person is still part of the household and that child is not leading an independent life. They may be in school, but where do they come during their term times? Do they come home? So once they are still living with their parents, once they form part of the family unit, they can still put them on as dependents.
So even if the child who is now an adult and they are 19, 20, as long as they still live with their parents, they can join their parents' application. Is that correct?
Yes, they can. And that it's important to realize that they must have had leave to remain as a dependent of their parents before they turned 18.
What if they don't live with their parents? Does that affect?
Some children don't live with parents because they are in school. Okay.
Yes.
So if you are in school, then they have to show why you are not living with your parents. So for instance, term time, you are in school, but during vacation, you come home. So all your addresses, everything, your proof of address, everything is still with your family. Then you should be all right.
Good. Guys, we've got an experienced immigration lawyer today who will be able to answer all your questions. We've got questions here from the audience. If you have any question that you want to ask Lawrencia, please put the question in the question section. It's not every day you have an experienced immigration lawyer who is prepared to answer your question. Let's go to the second question. So if you have a couple who moved to the United Kingdom, right? Say after 18 months, initially, the man was the woman's dependent. After 18 months of living in the UK, the man found a better job that offers him sponsorship. Would he be able to apply for indefinite leave to remain, having lived in the UK for 5 years? For 2.5 years, he was his wife's dependent. And for 2.5 years later, he is the main applicant. Would he be able to apply for indefinite leave to remain?
Okay, now with this one, it comes under appendix skilled worker. It's important that people realize that when it comes to appendix skilled worker, when you're applying for indefinite leave to remain under appendix skilled worker, you cannot include time spent as a dependent. Okay, so they cannot do that. What they can do is either the man spends the 2.5 years, extends the visa again for another 2.5 years, or a combination of, so let's say now they've given the person 3 years, for instance. If they give the person 3 years and then later on they give the person 2 years, or they give the person a straight 5 years, what the man has to do is the man has to spend time as a main skilled worker for that 5 years. Then he can now qualify to apply for indefinite leave to remain. He cannot combine a period spent as a dependent and a period spent as a skilled worker. When they are applying for indefinite leave to remain, they cannot.
Good. So just to be clear, so That means that for the man to be able to apply for indefinite leave to remain, he will then have to be on his visa for 5 years. That's altogether will be 7.5 years. 2.5 years spent as his wife dependent doesn't count.
Yes.
Okay, that is interesting. Thank you so much, Lawrencia. So the next question we have is, if someone is on a post-study visa and want to apply for another student visa, and they have more than 28 days on the current visa, will they be able to apply for extension while in the UK, or would they have to go outside the country to apply?
Now, the person has to be very tactful in this particular situation, because paragraph ST 43 of Appendix Student makes it very clear that when you're making an application in country, okay, you must be able to, like, the course that you are going to study, it must not start more than 28 days. So from the date your visa expires. So let me give an example. If, let's say, your visa is expiring on the 31st of August 2025, you make your application, the course start date should not be beyond 28th of September. So in this particular case, what the person should do is the person should speak to the university that they want to go to school with, explain to them their circumstances, okay, and the school should be able to issue the CAS letter stating that, making sure that the course start date does not start more than 28 days from the last day of the person's visa, from the day that the person's visa expires. So if the school is not ready to do that, the best thing is the person should leave the country and make the application and come back.
So the person have to ask the school for...
Yeah.
Okay.
Speak to the school. Some schools are very kind, okay, they'll do that, but it depends on when the courses start as well. So if the school can't do anything about it, of course you can't, but you may have to look for a course that actually falls within that 28-day period. The reason being that it's part of the validity requirement. So for the application to be received as valid, you must satisfy that requirement. So if you don't satisfy that requirement, they cannot accept the application as being valid. It's a risky thing to do. So it's imperative that they comply with that particular paragraph ST 4.3 of the immigration rules. Yes.
Okay. So the next question we have is, if someone came in as a student with a dependent, she is the main applicant and later got divorced, she now has a COS, which was granted to her. Would she be able to bring her dependent? I think this question applies to even people that came on the carers visa and couples, and if they became they had issues in the relationship and they get divorced. Would one of the couple be able to bring their dependent from outside the UK, given that there is not change in the law?
Okay. Now, I'm assuming, okay, based on what you said, that a person's COS was issued before 4th of April 2024. Now, if that is the case, then of course the Home Office made provision for transitional provisions. Now, the transitional provisions caters for people in that circumstance. What it says is, if your COS was issued before the new changes, you can still sponsor people. So with this particular person, once the COS was issued they actually, hers is in 2023, so he was way in before the changes. You can still continue to sponsor your dependent, your spouses, your children, provided you satisfy the other eligible requirements. If you are able to show that you satisfy the other eligible requirements, you can sponsor your family members to come to the UK. The key thing to note is, when was the COS issued? Okay, so if the cutoff date was the 4th of April 2024. So you've got to bear that in mind. If it was before that, you are fine. If it was after that, then of course, unless you formed part of a family unit, okay, you were on a visa that recognized you people as a family unit in the country, then of course you can't do much about it. But if you are here as a family unit, that's when you apply for Home Office to exercise discretion on your behalf. But with that particular question, insofar as that COS was issued before the 4th of April 2024, and the person had that leave to remain by that time, then they are fine. They can still sponsor family members. Yes.
Does that also apply for students who came into the country before students were stopped from bringing their dependents? Would they be able to bring their dependent?
Now, with the student rules, that one is different from the COS, the care worker visas. Okay. So what I always tell people is go back and check the transitional provisions. Okay. But currently, in relation to this particular one, there were specific transitional provisions that was made for the carers. So they are catered for.
So it sounds like what you're saying is that the carers will still be able to bring their dependent. For students, they may not be able to bring their dependent. Is that what you?
For students, you may not be able to bring, because when they stopped it, I think at the beginning of the year at the beginning of last year, when they stopped it, what they wanted, they had, when the Home Office bring in these rules and everything, they are trying to prevent people from coming into the country. So you've got to always check the transitional provisions. Okay, does it cover you? Does it not cover you? Very, very important.
Okay, so I think you've answered two questions. Yeah. So can a parent who have lived in the UK as an undocumented person, they have a child, that child came with them, they have all lived together for more than 7 years. Can the parents use the child to apply for leave to remain in the country on the basis that the child has lived with them in the UK for more than 7 years?
Now, we don't condone overstaying, but we do also know that sometimes people can become overstayers due to circumstances beyond their control. Now, if this should happen to you, okay, what you can do is, provided you can show that the child has lived in this country continuously for 7 years, that a child in that particular situation is deemed to be a qualified child. Now, those children, unless it is unreasonable, okay, you cannot expect them to leave the country. So currently, if you have a child who has lived in this country continuously for 7 years, and you can prove that it is unreasonable for them to leave the country, then of course they satisfy the private life grounds. So they can be given either 2.5 years or indefinite leave to remain, depending on how you make the application. Now, when that happens, the parents who are here can make applications under Appendix FM on the parent route. Now, Appendix FM, when it comes to the parent route, there are certain things that you have to satisfy. Now, of course, they are overstayers, so they will not be able to satisfy the immigration status requirements. That would mean something called Appendix EX1 has to be applied in their case. Now, in relation to a child, Appendix EX1 states that if a parent can show that they are in a genuine and subsistent parental relationship with a child, then they can be given 2.5 years and they can remain here as the primary carers of the children. So yes, they can do the application, provided they can show that that child has lived in this country continuously for 7 years.
Thank you so much, Lawrencia. As you heard from Lawrencia, if a child has lived in the UK with their parents who are undocumented, as long as the child has lived in the UK continuously for more than 7 years, the parents can use the child to apply to remain. That doesn't mean we're encouraging people to live in the UK legally, but that is the pathway that is open to parents. Thank you so much, Lawrencia. If you've seen any value in this content, don't forget to give it a like to support what we're trying to do and share. I will read all the questions. We've got questions from Trendy Topic. I'll read all the questions, but let me go through the questions that have been sent to us. Lawrencia, there have been a lot in the news lately about immigration and what changed to indefinite leave to remain, and carers who came in who are approaching 5 year stay in January next year, whether they will be able to apply for indefinite leave to remain. Can you please update our audience on where we are, please?
Now, the rules, I always tell people that your starting point should be the immigration rules. Now, currently, most people have access to the internet, okay? And it's important that I tell you, you can find the immigration rules online. You just have to type UK immigration rules or immigration rules HC 395 as amended. Okay, it will bring you all the immigration rules, everything that you need to know about the UK immigration rules. Now, if you don't find anything in there, that means it is not the law. Now, I do get the point that the Home Secretary, the new one, they, during the labor conference, made certain assertions. She made some statements showing that this is her intent, or that is the government's intent. This is what they want to do in future, but that has not become law yet. So as we sit here today, if you are eligible for indefinite leave to remain, if you can show that you've been in this country as a skilled worker with a combination of other routes, other immigration routes, okay, as stated in Appendix Skilled Worker, then you can make an application for indefinite leave to remain, provided you satisfy the other rules. Now, the Home Secretary, what she's anticipating currently is that they are going to tighten the rules in relation to getting indefinite leave to remain. But they've also indicated that it will not be it will not be applied retrospectively. So that basically means that those who already could apply for certain leave to remain will not be affected by it. It will be the new people who are making new applications. And I think it's a good thing for them to indicate that that's what they intend to do. But as to whether they will do it or not, we are still not clear. Now, what they are trying to say is, before someone applies for indefinite leave to remain, they are going to increase the level of, I mean, it's interesting how they say certain things, like the English language. You have to speak it to a very high standard. You must show that you are volunteering. You must show that you've contributed to the economy. You must have a clean criminal record. You must not, I mean, benefits and everything. It's important that you're not claiming those benefits. I mean, they will consider all of that in looking at the time that you can spend in getting indefinite leave to remain. But all these ones are statements of intent. It has not become law currently. So yes, they may do it in future, but they haven't done it currently. So as we speak today, the rules still remains. It hasn't changed.
Thank you so much, Lawrencia. I just want to quickly go back to the two questions that you've already answered before, because something that just came to my mind. So if you have a couple, they came to the UK before the changes in 2023. They came on a carer's visa, right? When they came, both couples, they are now divorced. Yeah. The man decides to remarry, and he remarries, and his wife is outside the country. Would the man or the woman who have now remarried be able to bring their dependent to the UK, knowing full well that carers are not allowed to bring their dependent, but he came before the change was introduced?
Okay, the key here is who was the main carer. Okay, we will not consider the dependent because the dependents cannot. Now, the question is, who was the main carer? So the main carer whose visa was issued or who got the COS before the rule changes in April 2024 is the one who can bring the dependent, not the dependent. Yeah. Okay. So the main, should I give a scenario?
Yes, please.
So if, let's say, I'm originally from Ghana, so I'll use a Ghanaian name. So let's say Kofi is the main applicant as a carer, comes into the country with Amma, who is a dependent, his wife, okay? They all enter the country, let's say January 2024. So the rules hadn't been changed at the time yet. And Kofi was working and doing everything as normal. Amma was also as a dependent, going about her business. But then they divorced along the line, okay? Now, your question is, can any of them bring a dependent? Now, if Amma, for instance, who was a dependent, okay, got a new COS in her own right before the new changes, she can. But if she did not, and maybe she got a COS after the changes, she cannot. However, Kofi, who was the main applicant, can bring dependent in country or outside country.
Thank you so much. The next one I want to go back to is someone who came on the carer's visa. The person has worked with an employer for over 2 years. For instance, they came as a social worker. They came as a carer. They then found another employer with better condition and switched to another employer, but in the same caring profession. can they apply for indefinite leave to remain, having worked in the UK for 5 years in the care sector with 2 employers?
Yes, they can.
Okay.
They can combine that all those periods. Yes, they can, because it's a skilled worker and a skilled worker, so it's provided for in appendix skilled worker. They can.
Thank you very much. So let's go to the next question, guys. Don't forget to give this video a like and share. Put your questions there. We'll come to Lawrencia soon. Lawrencia, so this question is about no recourse to public fund. If you have somebody who is on no recourse to public fund, when they apply for renewal, would having no recourse to public fund affect their chances of their visa being granted?
No, not necessarily. Now, let me give an example. If, let's say, you were granted leave to remain on 2.5 years, as maybe the parents of a qualified child, a British citizen, or someone who's been here for 7 years, and after you were granted a 2.5 years, you realize that, look, you are in need, you are struggling, you can't make ends meet. You apply for change of circumstances. So they now remove that restriction of your leave to remain and now allow you to have recourse to public funds. What you do is, when you are making your new application, if you want to continue on that particular route or route, you just have to apply for a fee waiver before your visa expires if you cannot afford the fees again. And then what you do is, they will give you, if they assess your circumstance and they realize that you don't have the means to pay the fees, they now give you a code that will enable you to make a new application. Now, provided you satisfy the other requirements of the rules, they will still grant you your 2.5 years.
Okay, and as you were telling me before, it will be better every time they are renewing, it'll be better for them to apply for fee waiver.
Yes, every time you are renewing, if you want to continue on the no recourse to public funds one that they've given to you, every time you are renewing, it's best to apply for the fee waiver. However, it's important to note that the Home Office will consider your financial circumstances at every stage in the application. So if, let's say, you do it 4 times, okay, because you're on the 10-year route to settlement, at every time, every fee waiver application, they will consider your financial circumstance. They won't look at your previous history. No, they won't. They will consider your circumstances at the time of making the application to decide whether or not to grant you the fee waiver or not, or to remove that restriction from your leave to remain.
Okay, that's good. Thank you so much, Lawrencia. So we've got a question here about indefinite leave to remain. I think Stacy has a question, but Stacy, can you please reframe your question about benefit, because it's not very clear. So the question here is about, for someone who has indefinite leave to remain and work visa, how long can they live outside the country before their visa is revoked?
Okay, now with this one, it would be best to do it in 2 segments. So we'll deal with the indefinite leave to remain first. Let me write this one down. We'll deal with the indefinite leave to remain first, and then the work visa first. Okay. So you said, how long can they live in the country before it is revoked, right?
No. How long can this, say for instance, I have indefinite leave to remain. I visit Ghana or Zimbabwe, my country. And how long can I stay there before my indefinite leave to remain is invalidated?
Okay. Now, with the indefinite leave to remain, normally, if you look at the rules, okay, if you got the indefinite leave to remain under the immigration rules like Appendix FM, you shouldn't leave the country. You shouldn't stay outside the country for more than 2 years. Now, if you stay outside the country for more than 2 years, the leave lapses, okay, unless you want to come back as a returning resident. So you have to now fill an application to come back as a returning resident, and you have to satisfy that some requirements. Now, if you made the application under the EU settlement scheme and you were granted settled status, with those people, depending on the country, if it's any other country but Switzerland, okay, the Swiss nationals, it's 5 years. So with those example, if that someone comes from Portugal or let's say Holland, for instance, okay, or Netherlands, sorry, those people, if they stay out of the country for 5 years, their leave lapses, the indefinite leave to remain will lapse by operation of law. Now, with those who are from the Swiss nationals, it's 4 years. So with the indefinite leave to remain, everyone, and it applies differently to different people. So it's either 2 years, 5 years, or 4 years. But depending on your circumstances, if you want to come back, what you do is you apply as a returning resident, or you make a new application under the EU settlement scheme. But what we always advise people is, why stay outside for 5 years? All you do is, if let's say if you're an European Union national who have settled status, you go for a year, come back for 6 months, go back. Just make sure that you don't have that continuous 5 years outside the country. Now, if the 2 years is applicable to you, why stay out of the country for 2 years and then you have to make a new application to come? All you do is stay outside for maybe 6 months, come back for a month, go back 6 months, come back for a month. So just make sure that there's a break in that qualified period that they refer to. Then you should be okay. Now, that is for those with indefinite leave to remain. Now, for those with skilled worker visa, the rules does not specifically state the number of days that you can spend outside the country, provided if you just want to renew your visas in country. However, you have to bear in mind that you are in this country mainly because you are supposed to work for an employer. Now, so if you spend prolonged periods out of the country, the question is, are you working for that employer? Now, the employers have got certain duties, okay, to make sure that they notify the home office. For instance, if you don't come to work for like 10 days, they have to notify the home office. If it's unpaid leave absences for more than 4 weeks, they have to notify the home office. Now, so if they notify them and they think that you are not in a genuine employment, then your visa can be curtailed. So what we advise people in that situation is, as much as possible, if you really want to work, stay here, work. Of course, you can go on holidays. You can go on with the permission of your employer for short periods and come back. But for the avoidance of doubt, and just to make sure that you don't find yourself in trouble, don't stay outside the country for prolonged periods of time. Now, when they are applying, some people may say, oh, my employer may give me the opportunity, but it will be strange for an employer to give you an opportunity to spend prolonged periods of time out of the country. The question is, are you really working for them? Now, under certain circumstances, that may happen, but whatever it is, even if you stay out of the country for a prolonged period of time, for instance, when you're applying for your indefinite leave to remain, you have to satisfy appendix, continuous residence. Now, that appendix, it comes to their notice that you spent around 180 days in a 12-month given period, that could affect your indefinite leave to remain as well. So I always tell people, make up your mind. What do you want to do? Do you want to stay here, or do you want to stay out of the country? And then based on that, make your decisions. But if you apply for that skilled worker visa and you think you want to eventually apply for indefinite leave to remain, then come, stay, finish your 5 years, and then you can do whatever you want.
Thank you so much, Lawrencia. Lawrencia's contact number. Please do not contact me asking me for Lawrencia's number. Lawrencia's contact number is in the description section of the video, and I'm going to give you her office number. It is 0182 733 7791. I repeat, 0182 733 7791. If you've seen any value in this content, don't forget to give it a like and share. Lawrencia, the question about how long those on care workers visa can live in the country before they apply for indefinite leave to remain, you said it's 5 years. Is that definitely 5 years?
Now, it depends. Now, with the skilled worker visa, it depends on the skilled worker visa. Some can do it within 3 years. It depends. But our focus currently is on the care workers. So with the care workers, it has to be 5 years. But the other highly talented people, okay, those ones, they have different different requirements. But for the carers, it has to be 5 years.
Thank you so much. You heard today that if you have a child and the parents are overstayer, if the child has lived in the UK for 7 years, the parents can use the child to apply for leave to remain and then use that to apply for themselves and stay in the country. If you know anyone who falls in this category that will benefit, share this video with them so that they can use that opportunity to apply to remain in the country. Lawrencia, the last question we have before we start reading the questions from the audience is about somebody who is in the country who is an overstayer. Can they marry a British or EU citizen and apply whilst they are in the country?
Now, that's an interesting question. Okay. I always like reiterating that we don't condone overstaying, but of course, under certain circumstances, people can overstay, and it will be it was because of something beyond their control. However, if you find yourself as an overstayer and you happen to genuinely fall in love, okay, with a British citizen or an European Union national, now, depending on how you get married or where you get married, you can obviously make an application as a partner of the person, depending on the circumstances. Now, so I'll give an example. If, let's say, you have overstayed, but you meet someone you genuinely are in love with and you want to get married to the person is a British citizen, okay? Now, you can decide if you come from a country where, now, when it comes to the, let me make a point on this one. When it comes to the validity of a marriage, okay, in relation to international law, it is the laws of the country where the marriage was celebrated that governs the validity of a marriage. So, for instance, someone from Ghana, if you take the Ghana proxy marriage, which is the customary marriage, which is a traditional engagement, or how people call it, where the families meet, they dress up, they have all these big parties and those things. So the customary marriage, it is recognized as a marriage in Ghana, and it can be done by proxy. So for instance, if the person who has overstayed comes from Ghana, for instance, okay, then what they can do now, it's important I mentioned Ghana because other countries like Nigeria, proxy marriages from Nigeria are not recognized. So you cannot use the proxy marriage from Nigeria. The two parties has to be in the country for that customary marriage for it to be recognized by Nigeria. But in Ghana, they don't have to be, they are not required. So that's why I use Ghana specifically. So if, let's say, they do the Ghana customary marriage, okay, it's recognized in law in Ghana, and then they bring it over here. Now, the person who wants to do the application can do the application provided there's a minor child involved. And this relates to human rights applications, not skilled worker applications. So the applications can only be done under Appendix FM. So if you have overstayed in this country and want to do a marriage application, it always has to come under the human rights, not the other rules. The other rules, you have to, like appendix skilled worker, you have to leave the country, make the application and come, provided you satisfy the rules at the time. But with this one, if the person is a British citizen, you have to also ensure, yes, you can do the marriage and bring it in, but then you have to ensure that there's a minor child involved. Now, if there's no minor child involved, or if you cannot show that there are insurmountable obstacles that will prevent the two of you from relocating to Ghana or outside the country, or wherever you want to go to, then the application will not be successful. So they can get married from Ghana, for instance, use the marriage certificate, provided they can show that Appendix EX1 is applicable. Now, if there's no child involved, they have to leave the country, make the application, and come back. If there's a child involved as well, what they can also do is they can get married in United Kingdom here. However, if you don't have leave to remain and you want to marry in the UK, you have to give a notice to the registrar. The registrar, under the rules, have to notify the Home Office that you want to get married. The Home Office have got 70 days to look into the marriage, whether it is genuine or not. Now, if they give you the approval, of course, you can get married here, and then you can use the marriage certificate, provided there's a minor child involved. But if there's no minor child involved, there's no need in doing the marriage and everything here. It's always best to leave the country, get married there, and then come back into the country.
Thank you so much. We've got some questions I'm going to read out. Trending news. Can you put your questions again? Because we've got so many questions that your question has just gone up. I think you have a question about somebody who's married to a British citizen and is an overstayer. He has lived in the country for 20 years. His question was that, can they apply for indefinite leave to remain? I think the answer to that is no. You cannot apply for indefinite leave to remain. You're married, you haven't filed, you haven't applied, use the marriage certificate to apply to remain in the country. You cannot just apply for indefinite leave to remain. But I think the question he wants to ask is, he and the woman, they live in the UK, they are married, but he's an overstayer. Can he apply on the basis of the marriage to stay in the country?
Now, if he's been here for 20 years, did he say he's been here for 20 years?
Yes.
Now, if he's been here for 20 years, okay, and he's lived with a woman for that 20 years, if there's no child involved, the best thing is for him to make an application on private life grounds that he has been in this country continuously for 20 years. That they will consider the application. But if there's no child involved and he makes an application based on the fact that he's a spouse of a British citizen, it will be refused. But if he makes the application on private life grounds based on the fact that he spent 20 years in the country, Appendix Private Life provides for that. So then you come within the rules. So he makes that application, they will give him 2.5 years on the 10-year route to settlement. Now, when he gets the first 2.5 years, within 6 months, he can now change to that of a partner of a settled person.
Okay, somebody asked a question that we've already answered. I think he said, if you came with a skilled worker visa with a dependent, and the dependent couldn't cope and went back to their home country and they are not divorced, can I remarry and bring the wife to the UK? The answer to that question is yes, if you were the main applicant before. If you were the one that was given the visa to come to the UK and your partner couldn't cope and she went back home, you will be able to marry another woman and bring her here. But if you came as the dependent, no, you will not be able to do that. Am I right, Lawrencia?
Yeah, if you came as a dependent and you did not get your skilled worker visa in your own right before the rule changes, then you will struggle to do that.
Okay. So there's a question here from Adriana. Please, what can you do if you came on a sponsorship as a support worker and your company give you 3 months notice that you cannot continue to remain? I think you have to find another sponsorship if your company gives you 3 months notice. Is that correct, Lawrencia?
Yes.
Okay. So I've got a question here. I am currently a graduate on a graduate visa and the company I work for is going to sponsor my skill visa. Would I be able to apply for indefinite leave to remain after 5 years? No. The years you stayed as a student doesn't count. You have to be on a skilled workers visa for 5 years continuously to be able to apply for indefinite leave to remain. Is that correct, Lawrencia?
Yes. And what I always tell people is always before you do the application, go onto the internet and look at the immigration rules. Now, with the skilled workers, and they've tried to make it very easy for people to actually find their way around the rules. So if you just type appendix skilled worker, it will show you everything you need to know about when you can apply for indefinite leave to remain or not, what you can do and what you cannot do. If it's private life application that you want to do based on the fact that you've been here for 20 years, you just type appendix private life. It pops up. Read through it, see whether you qualify or not. So they made it quite easy in a way to find the rules. So it's important that people read the rules carefully before they make any decision as well.
Thank you. So the next question is about spouse visa. How long can someone on spouse visa live outside the country?
Now, if you're on a spouse visa, initially, I'm assuming that when we talk about a spouse visa, it's for those with under Appendix FM. Is that correct? Or this one is a spouse of a skilled worker?
It's not very clear. Let's assume it's a spouse of a British citizen.
Okay, I'll answer for both. Now, if you are the spouse of a British citizen, once you have the 2.5 years, okay, you can spend time outside the country. Okay, for instance, if let's say you are attending you are continuing your education in, let's say, America, for instance, you can still go to school. You can, provided you come back during the breaks, okay, and the UK, you still deem UK as your home. You want to continue living here with your family. They won't have a problem with that. Now, apart from that, also, if you are married to a member of the armed forces, it doesn't matter the number of times that you spend outside. It will still be counted towards your the indefinite leave to remain period, if that's what they are worried about. But normally, if you get 2.5 years, they don't restrict you as to when to be here, for how long you can be here. It's only when you're applying for the indefinite leave to remain that it would become a problem. So you can be here, you can go out, come in. If you don't want to apply for indefinite leave to remain, you're okay. But what we suggest to people is once you've made the application, it's important that you abide by the rules so that when you're applying for the indefinite leave to remain, it becomes easier. And then after you get your indefinite leave to remain, you can stay outside for prolonged periods, provided you don't exceed that 2 years and so forth. Now, with the skilled workers, okay, some people are married to their spouses, okay, and their spouses are the main applicant, but they are the dependents and they've got businesses outside. Now, you can be going and coming back into the country, okay. However, if you are applying for indefinite leave to remain, it may affect your application because you may not be able to satisfy the residence requirement. So I'll come back to the same thing. If you want to live in this country and get your indefinite leave to remain, do not spend prolonged periods of time outside the country. At least within a month, within a year, you can spend maybe a month or two, and then you come back a month or two. But if you stay for more than 180 days, it may affect your indefinite leave to remain application, which is something you really don't want to.
Thank you. I've got 3 more questions that will end the program. The next question from Stella is: someone came on a student visa in September 2022 and switched to a care workers visa in March 2023, when students were allowed to switch without completing their course. Will it affect indefinite leave to remain application? I think the answer will be no. Is that correct?
Yeah, it won't affect. It shouldn't affect the indefinite leave to remain application. No.
Good.
Yeah.
So
unless she's trying to say, can I combine the student and the time I spent as a student? People like asking that question. No, you forget about the time you spent as a student. But if you started in March 2023, the time that you'll be eligible to apply for indefinite leave to remain, provided you continue to work for your sponsor or you continue to remain as a main applicant in another employment, which is still under the skilled worker visa, then the time will be March 2028. That will be the 5 years that you've accumulated for towards the indefinite leave to remain.
Okay, thank you, Stella. The years you stayed as a student doesn't count. It's the years you stayed as on the care worker on the student workers visa. That's when it counts. We've got the question here: if someone has until December 8th to apply, hang on. If someone is on a graduate visa and there's a company. Someone is trying to, I don't know what this person is trying to do. I am currently, okay. If someone has until the 8th of December and the person wants to switch from a skilled worker visa to a student visa, the course starts in January. When is the best time to apply considering the 28 days rule? So what he's saying is that he has until the 8th of December, but he wants to switch from skilled workers visa to a student visa. The course starts on the 8th of start in January. When is the best time to apply? Would that not be before the 28 days?
It has the cost. Now, the rules, when you look at the rules, the time an in-country application can normally be done within 3 months, okay? But what you have to be careful of is that paragraph ST43, okay? So even if you do it earlier, the school should let you know that the start date, okay?
Yeah, go ahead.
Even if the school, even if you make the application before your visa expires on the 8th of December, the course start date, okay, should be within the 28 days. So like we have the 8th of December. So if the course date is going to be more than, now I have to do maths here, right? Now tell the person to do, if the 28 days, so if from the 8th of December, we have 31st of December, just bear with me. Now, 31st.
So I think it's a case of as long as he applies before the 28 days, he should be fine. Is that correct?
If the start date, now it's important with the 28-day rules, the start date is very important. So if the visa expires on the 8th of December, the course start date should be within 28 days of that 8th of December. So if they cannot, the course start date doesn't fall within that 28-day window, it's best for him to go outside the country and make the application and come back.
Right. Okay. I hope that answers your question. We have loads of questions, but we're going to take 2 or no more than 3. I am currently on post-study with my spouse, but no child. I plan to apply for a student visa again as I cannot get COS. Please, will I be able to add my spouse as the student, if you meant adding your spouse when you are on a student visa, if you can add your spouse as your dependent, the answer to that will be no, because you're now applying and the rules have changed. Is that correct?
No, let me clarify that one. It
Okay.
depends. It depends on the course that they are doing. Okay. So if, let's say, for instance, it's a master's course, okay, that they are doing, and it's a course progression from what they did previously, what they can do is that master's course, if it has a research component, they can still add their dependent. Now, if it's a PhD course, if they've already done master's and it's a PhD course, they can still add dependent.
Okay.
Yeah.
Okay.
So it depends. It depends on the course. So
Okay.
what they have to do is they should go to appendix student, okay, and read through and through carefully, and then find out the exact courses that they can do or apply to. But the master's course should have a research component that it should be okay, or a PhD course, and it
Okay.
should be a course progression. Yes.
Okay. So I think this guy has reframed the question. He's asked if he said he's married to a British citizen, if the overstayer has been married for 20 years to a UK citizen, they have 3 children aged 13 and 22, can they apply for a settled straight away? The answer will be
No.
no.
They can't apply for indefinite leave to remain straight away. What they have to first and foremost do is find themselves recognized in the UK system. So you first and foremost make an application as a partner of a settled person on the 10-year route, because they will not, if they have overstayed, they will not satisfy the immigration status requirement. So in that case, Appendix EX1 will be applicable because they have a minor child who is 13 years old, not a 22-year-old. So they will be able to give him some form of leave to remain 2.5 years on the 10-year route because of the 13-year-old. But why have they waited for this long?
That is the question that even the Home Office, it will raise some suspicion. I'm going to go through another question because this guy has been persistent. I am on
but let them know that they can. Okay.
You can use the 13 years old and you start again from 10 years. You can apply for indefinite leave to remain straight away. That's Laurencia's answer. So
you cannot.
Elias, who said, I am on a PhD student. I got divorced with my wife and I went back to my country, remarried, of which I applied for her to join me. The visa was refused on the basis of deception. What can I do? So I think he came here before with his wife. They got divorced. He went back. He's on a PhD program. He went back to his home country, remarried again. The new wife application was denied on the basis of deception.
Now, with that ground for refusal, it's very difficult dealing with that, especially if the sponsor, the person applying for the person to come into the country, is not a British citizen or hasn't got indefinite leave to remain. The reason being that they frown on deception. So if you look at the immigration rules, they've made it very clear. If you use information or you disclose information which happens to be false, whether knowingly or unknowingly, I mean, it's wrong, but they do it. So whether you knew it or you didn't know it, once it comes out that there was some form of deception used, they will refuse the application. And even when you don't disclose that you've been refused a visa in the past, some people do forget, you will refuse it and you are normally banned for 10 years from making a new application. Now, in this case, unless they can show or prove that the alleged deception actually is not a deception, then of course it will be difficult for the wife to come back unless the wife waits for the 10-year ban to elapse.
So that
or
is
let's say if he gets indefinite leave to remain, then of course it's now on family life grounds. So he can now argue on family life grounds that a 10-year ban is too long for the family.
Okay. So Laurencia's email and contact details are in the description section. The office number is 0182 733 7791. I repeat, 0182 733 7791. Elias, so you will need to call Lawrencia and book a consultation appointment with her. I think your question, she's answered the question to the best of her ability. Share this video. We now know that people who have lived in the UK, couples who have lived in the UK, they have children or a child As long as the child has lived in the UK with them for 7 years, they will be able to use that child to apply on the basis that the child has lived here for 7 years. And also, we know that those carers who have lived in the UK, who came in before the laws changed, they will still be able to bring their dependent to the UK. And those who have lived in the UK continuously on the care workers visa can apply for indefinite leave to remain after 5 years. Share this video with anyone that you know will benefit. Don't forget to give it a like. Contact Lawrencia if you have any question. She's reliable, credible, made in Ghana, delivering for us in the UK.
I like Ghana.